Welcome to this comprehensive guide on Australian workplace laws. In today's video, we will walk through the framework designed to provide fair, safe, and equitable work conditions for both employees and employers. Throughout this presentation, we will explore the key areas of legislative framework, including anti-discrimination laws, privacy regulations, the Fair Work Act, and work health and safety laws. Let's begin our journey by understanding the very purpose behind these laws and how they create an environment that is just and supportive for everyone in the workplace. Australian workplace laws are the cornerstone upon which fair and safe work environments are built. These laws serve not only to protect individual rights, but also ensure that employers operate within a clearly defined set of standards aimed at minimizing risks and promoting equality. With legislation established at both federal and state levels, and in certain instances backed by industry-specific mandates, Australian workplace law covers everything from employment standards and dispute resolution to comprehensive safety measures. In this video, we will delve into each of these components, highlighting the major acts, their purposes, and the practical steps businesses can take to comply. We begin with the anti-discrimination laws, which lie at the heart of creating an inclusive workplace culture. Australia's legal framework in this area is designed to ensure that every individual, regardless of race, gender, age, or disability, enjoys equal rights and fair treatment. The laws are designed to eliminate direct discrimination, where an individual might be treated less favorably on the basis of a specific protected attribute, and indirect discrimination, which can occur when a seemingly neutral rule disproportionately disadvantages a particular group. At the federal level, several key pieces of legislation form the backbone of the anti-discrimination framework. The Racial Discrimination Act 1975 explicitly prohibits discrimination on the basis of race, color, national or ethnic origin, and descent. This act is pivotal in safeguarding individuals against unfair treatment in not only employment, but also in the provision of goods and services, education, housing, and more. It even contains specific provisions to address instances of racial vilification, reinforcing the importance of social cohesion and respect among diverse communities. In addition to the Racial Discrimination Act, the Sex Discrimination Act 1984 plays an equally important role. This act is instrumental in ensuring that discrimination on the grounds of sex, gender identity, sexual orientation, and related aspects such as marital status, family responsibilities, and even pregnancy is not tolerated in Australia. Equally critical is the Disability Discrimination Act 1992, which provides robust protection for individuals with diverse disabilities. Whether the challenge is physical, intellectual, or sensory, the law mandates reasonable adjustments to facilitate full participation in everyday activities. The Age Discrimination Act 2004 further underscores Australia's commitment to fairness by protecting individuals of all age groups from discrimination. Whether you are a young person just entering the workforce or a seasoned professional, the Act ensures that employment practices remain free from age-related bias. Furthermore, the Australian Human Rights Commission Act 1986 establishes a framework for addressing complaints related to human rights breaches and discrimination under international treaties. This act not only provides a mechanism for individuals to seek redress, but also reinforces the nation's commitment to upholding international human rights standards. It is also important to note that each Australian state and territory has supplementary anti-discrimination legislation which addresses additional grounds or provides localized mechanisms to handle complaints. For instance, New South Wales enforces the Anti-Discrimination Act 1977, while Victoria operates under the Equal Opportunity Act 2010. This layered approach ensures that while a common national framework exists, the nuances of regional issues are effectively managed. By fostering thorough understanding of both federal and state guidelines, businesses can better align their policies with legal requirements and promote a workplace that is respectful, inclusive, and fair. Transitioning now to another pillar of contemporary workplace law, let's turn our attention to the Privacy Act 1988, a critical piece of legislation that governs the handling of personal information. The Privacy Act is particularly important in today's information-driven world, where the protection of personal data is paramount. In Australia, this act mandates the responsible collection, storage, and use of personal information by businesses, information that may include sensitive details about employees or clients. One of the cornerstones of the Privacy Act is the set of guidelines known as the Australian Privacy Principles, or APs. These principles outline the obligations that businesses must adhere to in handling personal data. AP 1, for example, calls for open and transparent management. AP 3 lays out strict criteria for the collection of such data, signifying that personal information should only be collected when absolutely necessary for providing a service and with the appropriate level of consent from the individual concerned. In addition, AP 4 guides businesses on how to deal with unsolicited information. It is imperative that organizations have policies in place to determine whether to keep or destroy any personal information received without consent. APP 5 then reinforces that individuals must be informed about why their data is being collected and how it will be utilized. Following up on these principles, AP 6 ensures that any use or disclosure of personal information is strictly for the purpose it was originally collected. Security of personal information is another critical aspect covered under AP 11, which requires businesses to take reasonable steps to protect personal data from misuse, loss, or unauthorized access. AP 12 and APP 13 provide further protection by ensuring that individuals have the right to access and request corrections to any personal information held by an organization. For sectors such as accountancy, where the handling of highly sensitive information is part of everyday business, these principles are especially significant. They not only promote trust between clients and service providers, but also underscore the importance of maintaining strict data security protocols. As we move forward, let's now explore the fundamentals of the Fair Work Act 2009. This seminal piece of legislation forms the bedrock of workplace relations in Australia. The Fair Work Act outlines the rights and responsibilities of both employees and employers, creating a balanced framework that fosters cooperative and productive working relationships. The objectives of the Fair Work Act are manifold. First and foremost, it is about providing a framework that supports cooperation and productivity within the workplace. Employers are given a clear set of guidelines regarding their obligations, starting with ensuring that employees receive fair wages and benefits. The Act also plays a critical role in preventing discrimination and promoting workplace equity by setting standards that apply uniformly to all workers. Furthermore, the Act acts as a unifying force in the realm of employment law by standardizing workplace practices across Australia. By simplifying the legal landscape, the Fair Work Act helps to avert disputes and fosters a culture of mutual respect, a culture where disagreements can be managed constructively and where the rule of law prevails. In light of the detailed framework provided by workplace laws on anti-discrimination, privacy, and fair work, it is essential to turn our focus to one of the most dynamic areas of workplace regulation: work health and safety laws, commonly known as WHS laws. These laws are crucial in ensuring that the workplace environment is safe, secure, and conducive to productivity. They set out the duties, rights, and obligations of all parties involved, aiming to prevent workplace injuries, illnesses, and even fatalities. The WHS Act is built on a foundation of proactive risk management. It mandates that employers or persons conducting a business or undertaking, often referred to as PCBUs, actively identify hazards, assess the associated risks, and then take prompt steps to eliminate or mitigate these risks. For a business, this means routinely inspecting the work environment engaging in systematic risk assessments, and ensuring that any potential hazards are addressed through effective control measures. A key part of WHS law is its emphasis on consultation and cooperation. Employers are required to engage with their workers, seeking their input on safety matters and involving them in the development and implementation of safety protocols. This collaborative approach not only increases awareness about potential risks, but also empowers employees to take an active role in safeguarding their own health and safety. Employers are encouraged to develop a robust safety management system that addresses everything from everyday operational hazards to emergency response planning. Training is paramount, ensuring that all workers understand the safety procedures in place and are confident in their ability to respond appropriately in emergencies. Consider, for example, the procedure for hazard identification and investigation. The process begins with routine inspections of the workplace using a comprehensive checklist designed to spot any potential risks. Employees are encouraged to report any hazards they observe, whether these involve faulty equipment, unsafe work practices, or environmental risks. Once a hazard is identified, it is essential that it is properly documented, detailing the specific location, the nature of the hazard, and the measures taken to control or eliminate it. This documentation process is crucial, as it not only ensures a consistent safety record, but also provides valuable information should any incidents occur. In situations where incidents such as slips, trips, or other injuries occur, a clear set of procedures is in place. The first step involves ensuring the affected individual is safe and providing immediate first aid care if necessary. Following this, a detailed report is prepared, capturing the time, date, and location of the incident, along with a description of what occurred and any immediate corrective actions taken. Such practices, which are integral to WHS laws, not only assist in addressing the immediate situation, but also help to identify areas for improvement in workplace safety protocols. The common thread across all these areas of legislation, be it anti-discrimination measures, privacy protections, fair work standards, or health and safety requirements, is the underlying principle of fostering responsible and ethical business practices. For employers, understanding and implementing these laws is not just a regulatory obligation. It is also a commitment to creating workplaces that are safe, inclusive, and supportive. By actively seeking to comply with these guidelines, businesses demonstrate their dedication to maintaining high standards of ethics, transparency, and care for their employees. Let's summarize the key points we've covered today. Australian workplace laws provide a comprehensive framework designed to protect the rights of employees and guide employers in creating fair, equitable, and safe work environments. Anti-discrimination laws ensure that individuals are treated with respect regardless of their background, while the Privacy Act underscores the importance of managing personal information with care and transparency. The Fair Work Act establishes balanced workplace relations, setting clear standards for pay, conditions, and mutual respect. Finally, work health and safety laws focus on the proactive identification and management of workplace hazards to protect everyone in the work environment. For employers, HR professionals, and employees alike, these laws are more than just legal requirements. They are the building blocks of a successful, sustainable, and ethical workplace. As you implement these compliance strategies, consider the broader implications of your efforts, not only in terms of legal adherence, but also as a commitment to fostering a supportive workplace culture. As we conclude this instructional guide, remember that understanding these laws is the first step towards compliance. Maintaining an ongoing commitment to legal and ethical practices not only benefits your organization, but also contributes to a more just and equitable society as a whole. Whether you are an employer, a human resources professional, or an employee, your role in upholding these standards is vital. Thank you for joining us on this detailed exploration of Australian workplace laws. We hope that this guide has provided you with the insights and practical strategies needed to ensure that your organization remains compliant and thrives in a safe and fair working environment. Continue to educate yourself and your team, and together, let's build workplaces that reflect the highest standards of fairness, safety, and respect for all.